Good evening, everybody. I hope you are all doing well. Today is March 19th, Wednesday the 19th. If I'm not mistaken, I think spring officially starts maybe tomorrow, next couple of days. So I hope that where you're at, the weather is nice. Here in Atlanta, we had about 75 degrees. Took the dog for a walk in shorts and a t-shirt, which is really nice. And again, I know Jen tells me that in Lincoln, Nebraska, it's about 30 degrees. So every place obviously is going to be a little bit different, but I hope where you are, the weather is either nice or getting nicer soon. Obviously, a lot going on in the Social Security world, Social Security disability world. A lot of discussion about some new rules that the Social Security people are trying to put into place that requires folks to come in to physical offices or to uh, authenticate their documents all over the internet. Of course, the argument is that there are people out there who don't have internet access, so we can talk about that if you'd like. But right now everything is kind of proceeding as it always has. I know Social Security, there's going to be some cuts in personnel. I know the wait times on the 800 number are getting quite ridiculous, and delays in hearings are not getting any better. So that's where we're at. So anyway, let's jump into the comments, and of course, I'm sure if you have questions about those things, ask them. We can talk. Christina, one of my regulars, is here from California. Hello, Christina. Hope you are doing well. Thank you for joining us tonight. Um, Kevin Johnson basically says he has to do another adult function report. Social Security called and said the last one was 6 months old. This is ridiculous. He's been at the recon stage since May of 24. It's really getting harder to get disability when you've worked your whole life putting in the money that you may not get. I did reach out to my rep. I got a letter sent back, but I haven't heard anything back since. Nothing. I guess they're busy as well. Very upset about this. With the first, they said a medical examiner was looking at it. Now this is a whole lot of people being denied now. So I think big picture, what Kevin's talking about is Social Security sent him a form, which is the adult function form. And 6 months ago, he fills it out. And now they're saying it's 6 months old, send us another one. And of course, why is it 6 months old? It's because the file's been pending at reconsideration for, 10 months, 11 months. This is the new reality. I mean, I'm just going to flat out tell you, this is the new reality. Right now, I don't know that we're at the point where I would say it's becoming more difficult to win. There's no statistics to show that their approvals or denials have changed. It's just going to take longer. And Social Security, they offered buyouts to a bunch of people, and a lot of the people who took those buyouts are experienced folks. So the offices are running with less people, so it's going to take longer. And I think that if I had to say that the one thing that we can certainly say for sure is that things are going to take a lot longer. And you've done what I would tell anybody to do, is reach out to your elected representative, your senator, your United States representative, and say, I'm really suffering here. Would you enact or do a congressional inquiry to see if we can get things moved along? But this is just the reality of what we're going to be at. And I'm hoping that, I know that there's a lot of litigation going on by federal employees who are saying that, we were improperly terminated, and that this whole notion of decreasing the number of Social Security employees by 7,000 when it was already at a historic low, that may get shot down in court, but we'll see. But right now, I'm just going to tell you, your experience is not at all unusual. It can take, very well can take, recon a year, and I think that this is what I'm seeing in my practice: is initials taking 10, 12 months, recon's taking close to a year. Then you get to a hearing, it's going to be 7 or 8 months. So, I'm trying cases now that were filed 3 years ago. So you have to stay the course. I mean, I don't know what else to tell you. This is just the way it is. Sorry, Kevin. I wish I had better news for you, but right now this is what it is, and maybe it'll change. But right now, no. Blue Z says she was advised that her SSDI case is in post-review status. Had a hearing 3 weeks ago. All my medical records have been submitted. Is it normal to show for post-review status? That's very normal. Okay. She also said here, My thought is, after hearing, the judge should have some type of knowledge of what he feels about approval. Am I wrong? Is post-hearing review a concern about when all my medical records are in? I mean, basically, what actually happens is the judge hears the case, makes notes about important points, and writes down on a little form approve or decline. That is sent to a writer. A writer is typically a staff attorney, maybe a fairly inexperienced staff attorney, but this is what they do. Because I had a former paralegal who became a staff attorney, and this is what he told me he did. They are in cubicles in office buildings, and what they do is they listen to the hearing audio recording, and they look at the medical evidence, and they look at the judge's notes, and they draft a decision using a template. The template, when you've seen as many decisions as I have, the template looks exactly the same, and they basically, fill this template in with information about the evidence in the case, and that's the post-hearing review. It's all being put together, the evidence that supports either an approval or denial. Hopefully, in your case, an approval, and then the decision gets drafted up. It is then returned to the judge. Now, I've had decision writers tell me, in fact, one of them, and I'm going to try to get him on here, Spencer Bishon. Spencer was a former staff attorney for Social Security, and he said that sometimes he would look at a case and the judge marked denial, and he would contact the judge and say, wait a minute, this case needs to be approved. And I'll take him at his word that he did that. I suspect some attorneys will do that, although again, judges are going to make the decision they're going to make. And he said sometimes the judge would go with it and sometimes not. It depended on the judge to some degree. But the post-hearing review, very common. In fact, in all my cases, once the case moves out of active hearing, the hearing's been held, the first step is post-hearing review, where they're just looking at it to make sure the record's complete and all the technical stuff is done, for the case to be ready for decision, and the decision writer is putting it all together. So perfectly normal. This is just standard verbiage. That just means we're working on it. It is taking now, I'm seeing, anywhere, and I've had a few 2 or 3 weeks, but on average, 4 to 6 weeks to get a decision out. That's on average. And Spencer told me that, and you can go to ssdradio.com and look it up if you want to see my interview of him. He said that favorable decisions actually took longer than unfavorable because judges had to make sure that the favorable ones, had support, were supported by the evidence. So be that as may, take that for what it's worth, but it's not unusual for this term to be used, and it could take 6, 8 weeks even. So, all right, Tara says, hello, Walter and Chad. I'm not Walter. Walter is Walter Knott, I think you're talking about. He is another attorney who does a lot of live streams. Nice guy, but I'm not him. So he talks a lot faster than me, but he does a lot of live streams as well. But Tara, I'll assume you mean hello to me, so I'll take that as a hello. Hello, Tara. Unless Walter is somebody else you're talking about, I don't know. Sweet Candy is waiting to get approved or denied. Are you at the administrative level, initial recon, or are you at a hearing? So that it's going to make a difference there. All right, this is where I think you see this on the crawl there. If you'd like a case evaluation, I've got a website called ssdanswers.com. You can get a case evaluation there, and I'll tell you what I think about your case, whether I think it's got a good chance of getting approved. One question I'm getting a lot these days is, given all the chaos going on with Social Security, is it worth applying? And if so, should I do it now? Should I wait? I would say at this point, still, it's absolutely worth applying. And, unless and until the system is completely, changed, it's still going to be there. It's still going to be approximately the same, things being done the same way they're being done now. Again, maybe a little bit longer. If it changes, of course, I'll let you know. I would say, though, if you're going to apply, do it, because, waiting, things are probably not going to get better as time goes on. So I think that if you are going to file, go ahead and get that application filed so that the current rules apply to you, because any new rules that come out probably will not be as helpful to us on the claimant side. All right, so Kevin says, what if you're retiring? How long will it be the same as applying? Well, if you're talking about retirement disability, no. I mean, if you're at 62 and you file for retirement, that will happen right away. because there's no determination being made. In a disability case, we have to prove you're disabled. Retirement just to show your age. And then so if you take early retirement, you'll have money coming in right away. If you eventually win your disability case, Social Security will bump up your amount to the full retirement amount, because at early retirement at 62, you're giving the government a discount. You're basically taking 75% of your full retirement benefit. Whereas if you get approved for disability, it goes to 100%. The downside is if you don't get approved, you're stuck at that 75%, that lower, early retirement figure, forever. So that's the thing. But many people like to go ahead and file for retirement to get the money coming in. I will tell you that it may make it if you take retirement, it may make it a little more difficult to get a lawyer, because we get paid a percentage, 25% of past due disability benefits. Well, let's just give an example. Let's say that your let's say your full disability benefit is $2,000 a month, and your early retirement, which again is going to equal to full disability, but early retirement is, let's say, $1,500 a month. If you take early retirement, then as of that date, the difference between early retirement and disability or full retirement is $500 a month. So let's say your case is pending for 18 months. Well, $500 times 18 months is $9,000, which is not an insubstantial sum of money, but attorneys get paid 25% of that. It's a lot less than if your past due benefit was $35,000 or $40,000. So, some attorneys look at it and say it's not worth it. If I see a case where the early retirement amount is like $1,100 or something, the difference between early and full may be $300 or $400 a month, multiplied times however many months the case will be pending, may not make any sense economically for me to take it. So some attorneys see it that way. If it's, on the other hand, a larger number, it would make sense. And, again, I'm going to look at every case individually, but I just point that out that, that maybe could be an issue for you. Okay. This guy's checking systems. Very good. St. Louis Grand. Based on the reading of a case in Justy, an ALJ restricted a claimant from ever partaking in team activities in their denial instead of granting a case. Odd cop-out gatekeeping. Okay, so are you saying that the ALJ said that the claimant could not participate? I mean, I don't think ALJs have the power to tell somebody what they can and cannot do going forward. In the hypothetical, the ALJ may have said that this hypothetical person, any job this person has, must not be a job that involves team collaborative efforts. That may be what you're talking about. And that would be a way to limit the number of jobs that exist. So obviously, there are some jobs that one does on one's own. There are other jobs that are more of a collaborative process. You're working as part of a team. For example, a nurse would be working, an operative nurse would be working as part of a team in an operating room. So if a person had a limitation that they could not work in a team environment because of PTSD or because of problems interacting with males, let's say if it's a female who'd been sexually assaulted, something like that, that could be part of the hypothetical. But a judge and Social Security does not have the power to say to Mr. Grand, you are not allowed in your future to do anything involving team activity. So I think it's part of a hypothetical, and it is a restriction that would eliminate categories of jobs. So in that regard, it's a good thing. Obviously, you need more restrictions than that because there are many jobs that do not require team activities. So if that's the only restriction you've got, you're going to lose. But if you've got additional things, that's one thing to eliminate, a chunk of jobs, which is again what we want to do. Lisa C. Just got denied. I left you a voicemail and email. Jen never heard back. If you received my case eval, I'll email again. I'd like to hire you for my appeal. Okay. Lisa, just, what I'd like you to do, just email me directly. SSD answer is 123@gmail, and I will respond to you. So again, we get a lot of people inquiring, and normally Jen is not involved in that part. Jen is my paralegal. She's involved in the case management, so she's not really involved in the call in the new case evaluations or screening. I have a couple people that work with me on that. So Jen would not be the person that you'd be dealing with. So Madeline would be one, and Darlene is another. So either Madeline or Darlene would be, if you've heard from them, or that would be the person to reach out to, or you can reach out to me directly. Okay, Corlil Katana. Greetings. I was initially denied. I'm going to what the VA called higher level review. I forget what SSA calls it. I'm a client. What should I expect? Well, again, at initial denial, the next step is to file an appeal, which is called a request for reconsideration. I wouldn't call it a higher level review. Basically, it's the same people who made the initial denial. What they're supposed to do is to, if for example, on the initial denial, it says on there, we use the following medical records to make a decision in your case, but we were not able to obtain these records, and they may list 3 or 4 doctors they couldn't get from. In theory, the adjudicator at the recon level, again, the same state agency office, is supposed to make more of an effort to locate missing records or any updated records and give you a chance to say something has changed for the worse. In reality, recon is a waste of time. Statistically, they say statistically about 15% of people who file recon actually end up getting approved at recon. I think it's probably, as a practical matter, probably lower than that. I mean, I've done this for well over 30 years. I would probably tell you, 5% of the cases that I'm winning are approved at recon. Some are, but it's kind of a waste of time. And I think the practical effect of recon is to discourage people. They give up, and it just because it's going to add another year to the process. As somebody just said, they were waiting almost a year, but you got to go through it. So I sort of see it as, if we can make an argument at recon that was just ignored at initial, maybe the adjudicator at initial was overworked, new, whatever, I'll make that argument again at recon. But I tell my clients, I would tell you, this is not a high probability of getting approved. Recon just statistically is not. And the people that are making those decisions are really the same level of training, the same, mentality as the people at initial, who are basically looking for listing level impairment. And in fact, the cases I get approved at recon, many times what they do is they approve it, but they change the onset date to reduce past due benefits. So, I don't have a lot of really positive things to say about reconsideration, unfortunately. Rodney, how are you doing? Good to see you again. Rodney is a longtime client of ours. Actually, another attorney in my office did his case, won it in front of a really, really difficult judge, which I was thrilled to see. And Rodney has kind of been kept up with us since then. In fact, we had to get a copy of his audio for his disability case and get it converted to MP3, which I did, and he needed a referral to a VA lawyer, Veterans Administration lawyer. I don't do that work, so I gave him the name of a colleague of mine who seems to be doing a good job. So thank you for letting me know that, Rodney, and good to see you, and thanks for tuning in. Shub 281 received a letter from SSA telling me to call, verify direct deposit, completed this. Is this a good sign or standard operating procedure? Don't know. I mean, I think that if I had to guess, I would say it's more of a good sign. They're not going to ask you for direct deposit information if they're not planning on approving you. So I think it's a good sign. I've never seen anything that says this is an indicia of a case about to be approved, but logically it would seem to be a pretty good sign. At a minimum, it means that your direct deposit information is in there so that if you are approved, it's one less thing they got to try to track down. So I would say, yes, overall, I would say it's probably a pretty good sign. Vince, how are you doing? Hope it is warmer where you are than where I'm at. So it's quite nice here. I hope you're in, I always forget, Michigan, I think, where I think it was last time you told me it was like freezing. So it is cold. So anyway, good to see you here. Thank you for tuning in. George Graham, good to see you. George, that is quite the picture you got there. George must be a fan of Snapchat, because that is a scary looking picture. My granddaughter, who's 18 months, we have this thing where She's sitting on my lap, and I'll go into Snapchat. If you know what that is, they have these little filters where you have these ridiculous looking wigs and faces and so forth, and she just gets a big kick out of it because I make her look with a big black hair or brown hair or red hair, but a nose ring in there, and she's looking. I'm like, is that me? I'm like, yeah. So looks like George did the same thing there. Trish, and I know I'm not going to put it online, so something for her down the road, maybe in a wedding video. Trish Wade, how are you doing? It's the sign. Okay, I don't know what the sign is, but hopefully it's a good sign. Kelly Maynor, hello from South Carolina. Hello, Kelly. I hope you are doing well. I always like South Carolina. We've been to Hilton Head many times to go to the beach there, and it's real pretty there. I really like that. Mark, we had our hearing recently. How are you doing, Mark? Hope you're doing well. It is 67 degrees in Austin, says Pricey Joy. Not too bad. That's pretty reasonable. The nice thing about 67, 65 is open the windows at night. You have to turn the heat or the air on, and you get some nice fresh air. So that's what we do here. Okay, Will Johnson. How do I request a review of a denied claim older than 4 years old? Really difficult. I mean, basically, you're going to have to prove that you were deliberately misled by Social Security into not appealing. That's just a real uphill battle. It's almost impossible. I don't know that I've ever seen one. Theoretically, there is law that says that if you can prove somebody at Social Security told you not to appeal, you might be able to do it. But that's about the only way I'm aware of that you can do it. But I think it's really an uphill battle to get it reopened after 4 years. Okay, Justin, you. Do I argue at a hearing I'm 12.06 the grid rules for lower body issues or both? I would argue both. I mean, I think that, anytime you have multiple arguments, and you can also argue the combination of physical, mental health issues, that's a functional capacity issue as well. So there are 3 theories of disability that one can use to win. One is called meeting a listing. Website is meetalisting.com. It's my website, where you can look at the listings. And the listings are where Social Security has identified within 14 body systems specific diagnoses that are disabling, and that, along with a small functional, I wouldn't call it capacity, but small functional issues that go along with it. So in the musculoskeletal listing listing one, you may have a herniated disc with inability to walk, or with lack of use of your upper extremity, or whatever it may be. So there's always going to be a little functional issue there. So if you meet a listing, a mental health listing, let's say, you would argue, I believe I meet this listing. Now, I'll tell you that judges generally don't see listing level cases because they usually get picked off at initial recon. But you can't make it the argument. Make that argument that you think you meet a listing, and here's why. If you're over 50, or even more so if you're over 55, you make that grid rule argument, and you would argue that, for example, if you've got mental health issues, depression, anxiety, things like that, that makes any transferable skills, void, because you can't focus and concentrate or remember or be emotionally stable. So that those non-exertional problems would help you meet the grid, because part of the grid is usually going to be, transferability of skills or ability to directly enter into skilled work. So when if you've got lower body issues that help you, orthopedic issues that help you meet the grid, that's where you would make that argument that there's both the physical part of it and then the lack of transferable skills or ability to enter into skilled work. So you do meet the grid. And the third argument would be, so we have meeting a listing as one, the grid rules, gridrules.net is my website for that. That's number 2. That's theory 2. The third theory is functional capacity. The way to look at that would be almost like a kitchen sink argument. You throw in the mental, the physical, the combined effect of all these problems, medication side effects, even things that are not on their own disabling. You've got sleep apnea, which is, contributes to non-restorative sleep, or you have, something that let's say that you've lost your sense of smell, which is going to, eliminate a very few number of jobs, but again, it may interfere with you in terms of your mental state. So you put everything in there, and you essentially say the combined effect of all this would mean that my capacity to be reliable at work has been so reduced that I could not get through an 8-hour day, 5 days a week, either because of problems with focus and concentration, or being what they call off task for more than 10 to 15% of the day, or because my condition is such that I'm likely to miss 1 or 2 days of work per month on an ongoing basis. And so if you can argue all three of those things, then let the judge choose which one that he or she's most comfortable with. A lot of my cases, I argue grid rules. A lot of my clients are over 50. And what's interesting is that judges will usually approve the case using a functional capacity theory, talking about the functional issues that have been reduced, and a person wouldn't be reliable. Then they'll say, even if there's more function than I'm finding here, the grid rule at 202.06 would dictate a finding of disability. So, judges will use all of them. But I think if you want to go to a hearing, present all of those and give the judge the option for all of them. And judges are going to do what they're going to do. But I think if you make that argument, at least you're saying, here's what I think, this is why I think I'm disabled. And you may narrow the scope of the hearing, which is a good thing. Paul has been in recon since, I think you reached out to me, Paul, if I'm not mistaken. The reason I remember because there was a lawyer in Atlanta named Paul Parker who did a lot of advertising for bankruptcy years and years ago. But anyway, that has nothing to do with anything. But yeah, recon since September of 23. That's ridiculous because, now we're looking at well over a year. This is where I would reach out to my elected representative and say, I've been at recon since 2023. We're now in 2025. It has been, a year and a half, more than a year and a half. It's ridiculous. And I would also tell you, Paul, you want to make sure that your case has not been denied and you didn't get notice of it. It's fallen through the cracks. You need to make sure it's still active. And what I'm saying, one of the fallouts to the lack of staff is mail's not getting sent. I have a case. In fact, I talked to an adjudicator a couple of days ago. We see online a decision has been made. Okay. We don't have a copy of the decision. The client doesn't have a copy of the decision. So the case is recon. And so decisions are made. So my paralegal and I were talking about it. I'm like, well, we need to file something. I don't want to just not do anything. So I filed a request for hearing. And what I basically said was, we don't have a copy of a recon denial in here. We do see online that the case has been closed on the electronics record express. It's been closed. I'm assuming that it has been denied. If so, please consider this an appeal. If it has been approved at the original onset date, please disregard this. I don't know if that would work. But I had to do something. So I get a call from the adjudicator. Oh no, it's not denied. We haven't done any. We have not made a decision on it yet. So why is it showing closed? I don't know. So who knows? So I'm concerned about in this case. I'm just going to leave things as they are because I want to have a paper trail in case they later on come back and try to say, oh yeah, we denied this. I have a hearing case that I show is being denied. Never got a decision. It's not in the electronic folder. Client hasn't gotten a decision. What do you do? And this is the problem: is that the staffing problems are that they can't get the mail out. And this puts my client in a real bit of jeopardy. How do you appeal to the appeals council if you don't know why the judge denied the claim? So crazy. Austin Vibe. After December 17th, 24 hearing at the 90-day mark, the judge wanted to do a supplemental hearing to ask the additional questions due to some new law. Yes. Would you explain it? What's most likely happening is that Social Security changed the look back for past relevant work from 15 years to 5 years. This is a benefit to you as the claimant because when they're looking at transferable skills, if you have 15 years worth of past work, there's likely to be more transferable skills. Only 5 years, in some cases you haven't worked in 5 years, there may not be any past relevant work, or the work you did 5 years prior to the hearing was part-time and didn't rise to the level of substantial gainful activity, or you were working, let's say, at a high level warehouse manager, let's say, in the last 2 or 3 years, because of your medical problems, you were driving a forklift or you were doing construction or something like that. So you may have gone from a skilled occupation, 6 years, 7 years ago to an unskilled occupation. The 5 year look back means they can only look at the last 5 years. So I suspect the judge was, when the case was originally heard, was asking the vocational witness to give examples of transferable skills from the last 15 years. Now, the supplemental hearing, the judge is going to say, I can only ask about the last 5 years, and it may eliminate some of the past relevant work or any transferable skills. So, in sum, this will help you. This is a positive for you, having this done. So, now on the flip side, the judge is doing a supplemental hearing. If the judge wanted to approve you, it wouldn't really matter, if you think about it, if you had transferable skills. If the judge wanted to approve you, if he or she felt that the evidence was really strong. So, I would regretfully tell you this probably means the judge is looking for, the evidence that he or she would need to turn you down, by saying that even if looking at the last 5 years, either there are transferable skills or the person has the ability to move into skilled work, whatever. I could be wrong, but I'm just, supplemental hearings, for that purpose, given the change in the look back, probably not a great thing. But again, I could be wrong, and I want you, if you could, let us know what actually happened if your case. And I hope I'm wrong about that. But that's what's going on. It's because of the change from 15 years to 5 years. All right, so Paul's the one who said he's been waiting since September 23, so he applied in March of 22. So we are now in March of 25, 3 years, and he's still at recon. Paul, you got to reach out to your representative. You got to find out if your case is still active, because this is just, something's not smelling right here. I'm just telling you. Jim, my doctor waffles on neck surgery. Always says can't promise an outcome. C4 to C7. Let me decide to elect surgery. State. Let me decide to. Can't promise an outcome. Let me decide to elect surgery. State management. Can this hurt me? No. I think that many doctors will tell people that surgery, especially if you've got nerve damage, that surgery. I've had people tell me, the doctor said, well, there's a 30% chance that you'll get better, 30% chance you'll get worse, and 30% chance you'll stay the same, or 35, 33%, whatever. And if there's 2/3 of a chance I'm going to stay the same or get worse, why would I undergo surgery? Point one is that Social Security will not punish you for refusing to undergo surgery. If you have a good reason, that would be concern about a negative outcome. So I think it will not hurt you. I think you've got to make a decision about surgery based on what you think is best for you medically. I will tell you, again, just my opinion, I would get a second opinion. My wife does workers' comp here in Georgia, although I'm national, as you all know, for Social Security, but she's a local for workers' comp. And, the stories she tells me about the doctors that do workers' comp in Georgia, there are some really good ones, and there are some doctors who just aren't that good. And, they're doctors who specialize in knees, but are being asked to do neck surgery, or a doctor that specializes in, shoulders is asked to do a lumbar fusion, or sometimes you need a neurosurgeon rather than an orthopedist. So, I would reach out to some people, even if you call some attorneys that do, comp attorneys are going to typically know, get some opinions, get a second opinion by another doctor, have them look at your records, the MRIs and so forth, and get a sense, if you're not feeling it from this doctor, and the doctor's waffling, that's not a good sign, because, you want, not that you want the doctor to say, I guarantee you, they're not going to do that, but you want them to say, yeah, I feel pretty confident we can go in here and make a difference. And if the doctor's like, I'm not so sure, up to you, that would not give me the warm and fuzzies about that doctor. I think I would get another opinion. If you get another opinion, or two opinions, and everybody's saying the same thing, that it's just a crapshoot, maybe you get better, maybe you get worse, maybe you stay the same, my thought would be, don't do it, because back surgery, it's invasive. You're under anesthetic, which is, people don't realize this. Going under anesthetic is not the healthiest thing for you. And, once the surgery is done, you can't undo it, and you could end up a lot worse. So But I think big picture here is, my wife is fond of saying this, you have to be your own advocate. You have to be your own healthcare advocate. And, if a doctor's telling you one thing and you're not feeling that the doctor's giving you the information in a way that you're comfortable with, nothing wrong with saying, I want to get a second opinion. And good doctors will not discourage that, and I think that, you have to be willing to, just take that step. I wouldn't ask your doctor for, a referral to somebody else. I would ask a third party. But there are plenty of people out there, I'm sure, where you live, that, are familiar with doctors, whether it's physical therapists that you may know, or again, contact a comp lawyer, workers' comp lawyer. I know it sounds kind of crazy, but contact a comp lawyer and say, look, I know you deal with orthopedics and neurosurgeons in my city or state. Anybody you recommend, and get some names and call two or three of them. Most lawyers will be happy to talk to you about something like that, and get some names. You start hearing the same names, see who the doctors are. If there's a professional sports team near where you are, who are the doctors that treat them? They all have staff, orthopedics that treat them, whether it's hockey or football or baseball. Those people in that practice are probably going to be pretty good. So, you have to just look around, but, you got to be your own advocate in this. All right, so Pricey Joy, this is in response to someone was asking, Justin said, do I argue at a hearing? Pricey Joy, here's my thought. I don't think it's about preaching to a judge. I think you can just respectfully say, Your Honor, I would respectfully ask you to evaluate this case under listing 12.08 or listing 1.04, 324, whatever it is. I would also ask you to consider this grid rule 202.06, but I believe I meet that. In the alternative, I would ask you to consider a functional capacity argument. Honestly, you should have a lawyer do this. You shouldn't be doing this yourself. But if you are doing it, you can ask the judge to evaluate. And I do this in my appeals and in applications many times. You can respectfully ask them to analyze it under this theory of disability. And I think judges actually like that. I had a case just the other day where it's a kind of very interesting facts of it. And the judge and I made an argument, and he responded. He said, I hear what you're saying, but here's my thought about this. And he gave me his opinion. So he gave me some ideas about some other arguments. I'm going to do a post-hearing brief. Judges want to get it right, most of them. I'd say the majority of them want to get it right. So, yeah, it's nothing wrong with saying, here's something to consider. They probably have thought about it, but, nothing wrong with putting it in black and white, in my opinion. So I don't think, Pricey Joy, it's disrespectful to a judge to ask him or her to consider a particular theory of disability. Stargirl says, do I bother paying $1,000 to see an Ehlers-Danlos specialist? They don't take insurance. My multiple specialists know that I have it, but they can't treat me for it because of various comorbidities. Again, Ehlers-Danlos, which is a hypermobility of the joints, and it is difficult. I'm assuming that's what you're talking about, EDS. It is very difficult to treat because it's a genetic, problem. And, people get their joints dislocated very, very easily. And it can be very, very uncomfortable. And there's other, a lot of times it's associated with other conditions. There's I think it's a malformation in the back of the neck. There's another one where when you stand up very quickly, you lose your, can lose consciousness. So there's a number of different things that go along with Ehlers-Danlos. If you have other specialists that will talk, that you mentioned you've got Ehlers-Danlos, and will basically say that, your functioning has been significantly impaired, you may not need to spend that money for that. On the other hand, an Ehlers-Danlos specialist saying that your level of it, the degree of impairment you've got, is very, very significant, would certainly help you. But, again, if you're in a disability case, this is where a lawyer can advise you, I think we have enough here, or I think we need more. And $1,000 to see somebody for an opinion, maybe it's a good investment if it puts you over the top. But if you've got a bunch of other specialists, who are saying, we can't treat Stargirl because of, her, rheumatoid arthritis, or because of her cardiac problems, or because of her neurological problems, whatever, the other situations may be, and that these problems, are inherently disabling and are Ehlers-Danlos makes it even worse, can't be treated, that's one thing. But if they are not able to comment about the level of impairment you've got, then maybe that specialist could come into play. I don't want to. I hate to waffle on this. I don't mean to not give you an answer, but $1,000 is a lot of money. I think it would really depend on what the record says and how strong it is otherwise. And if there's enough of an implication that your Ehlers-Danlos is at a level of severity that would preclude various types of treatment, and you've got these other comorbidities, that may very well be enough. That's how I'll answer that. Richard says, wish me luck. I have your hearing Friday afternoon. So he has got his hearing in 2 days. Richard, I wish you the best of luck. I hope it goes well for you. And again, people always say, what's your advice? The main advice I would tell you is when you discuss your limitations, like sitting, standing, walking, avoid not very much or not very far. 10 minutes, 15 minutes, 10 pounds, I don't know, 30 yards, whatever the particular, unit of measurement might be. You want to be very, very specific with that. Because if you get into a hearing and say, well, I can't sit very long or walk very far, or after a prolonged period of time, I get very uncomfortable, that doesn't tell the judge darn thing. So you want to be really, really specific about those things. If you have to take breaks to rest, every 3 hours, I have to take a 25 to 30-minute break because I'm pain at such level, I've got to lay flat and get the pressure off my neck, or whatever your impairment might be. But you want to quantify, minutes, distance, pounds, things like that, as much as you can, and talk to your lawyer. Again, like for example, lifting. This is something I deal with a lot, especially with men. Is how much can you lift? Well, I can lift about 25 pounds. But really, 25 pounds is a lot of weight. I mean, it really is a lot, especially if it's not like like a barbell. If it's like a big box of something. In fact, I was going to do a video, lifting a recycle bin, which is about 25 pounds. Well, it's awkward. It's hard. If you've got a bad back, you're not doing that, 10, 15 times in a day. So I think you need to really think about how much you can really lift, and on a regular basis, frequent basis, which would be let's say 2/3 of the day, and occasional, which might be 1/3 of the day, maybe 2.5, 3 hours. Still a lot of weight. So don't feel like you just throw a number out there. Really think about it, and if you can, test yourself on it. But just don't throw out numbers 25 pounds or 20 pounds. It's a lot more than you think it is. Even a 10-pound bag of potatoes can be heavy if you've got back pain or if you've got neck pain. So just try to be real specific. Deb Lindley from rural northern Iowa. It was 67 degrees in Iowa. Wow. And today it's 28, 6 inches of snow. Well, that's what you get for living in Iowa. If you came to the South here, you wouldn't have those problems. But I'm sure I've never been to Iowa. I know I give Jen, my paralegal, who lives in Lincoln, Nebraska, I joke with her a lot about the weather in Nebraska, so I'm sure in Iowa, I'm sure it's beautiful country out there. And, it's not big city living, and there's a lot to be said for it. But the weather ain't one of them. And having, 28 degrees and 6 inches of snow in March is, not exactly what I call fun. But I'm sure there's some other things about living in Iowa that are really, really nice. I'm sure you'll tell me about them. But, that is pretty cold, and you can have it. That's not for me. Not for me. And Pricey Joyce says, I'd rather have the snow. Nah, not me. Not me. All right, Tara Denise, I get SSDI and applying for SSI for your daughter. What about, why don't you look at a disabled adult child as opposed to SSI? If you're on disability and your daughter, I think became disabled before age 22, I can't remember the exact thing, but she never worked. But I think that, her disability is obviously lifelong, is what you're saying. It's always going to help to hire an attorney. With the initial app, not necessarily. I mean, I do them for people, but attorneys do them. You don't need to really do it for any, for initial app. I think, hearing, yes. But I would look at the very least, I would look up something called disabled adult child and see whether or not your daughter might qualify that. Because if she's disabled, you know, essentially would disabled lifelong, and you're on disability, she could claim on disability, not SSI, and it would be more money would be under the disability program, not SSI. So Jim says it was 74 degrees in eastern North Carolina. Okay, well that's again very similar to here, so that's good. 74 is the tropics. I don't know why I'm in Texas anymore. Well, Texas is such a big state that my understanding is you can go the way south where it's really, really warm to northern Texas where it gets kind of cool. So, it depends on where you are in Texas. I've been to Houston and I've been to Dallas, but both in the summertime. So, which is kind of hot, obviously. But, Texas it really could be its own country. It's that big. Susie B says, good evening. The wait times in the SSA national lines are ridiculous and local disconnect. Trying to correct a DAC application disabled without child, the SSA worker filled out wrong during initial, I'm sure is difficult. Yeah, I actually saw that was interesting. There was let me find it. A person that was on Twitter. I don't go on Twitter very often, but this one just kind of jumped out at me. It was a lady who's 80 years old. I'm pulling it up right now. And she called Social Security, and they basically said that the average processing time is 200 to 230 days. And this is a message from Social Security. Estimated hold time is greater than 120 minutes. That's crazy. That's just crazy. So, yeah, this might be a situation where, I know I sound like a broken record, but, contact your elected representative. Just say, look, I can't, there's no way I can get a hold of anybody there. Can you help me with this? This is what they're supposed to be doing. They're supposed to be your representatives, and let them know you're not real happy about this. Can they help you? And most senators have a person who is dedicated to Social Security matters, and they will make a phone call, and things tend to happen. So I would lean on your representative on that. Yeah, getting on the phone is not good. Not good. Ms. Crystal, I received workers' comp in 2022. Just got approved for SSA. Another trying to figure out my back pay. The reason for that is that workers' compensation offsets Social Security. So when you settle your workers' compensation case, there should be language in the settlement. It's called Hartman language that basically says this lump sum of $80,000 or whatever it was is to be treated as if it was paid out over the claimant's expected lifespan using this mortality table. And based on this table, she has 37 years to live. If you divide that $70,000 by 34 years or whatever, you get this. And this is what the offset is. If you don't have that, they will offset your Social Security dollar for dollar for the full amount of your settlement. So that's what they want to make sure is the comp has been settled and has the right language in it. That's what's going on. Miracle after miracle. Hello, Miracle. How are you doing? Esoteric Fitness is here most weeks. A TBI survivor. Good to see you there. Bluesy. So before post review, the judges. Okay, so Bluesy had asked about post hearing review. What I would tell you is the judge has written down his decision on a either not a piece of paper, but noted it down. But so the decisions have been made. It doesn't mean that decision can't change, but obviously most of the time it's not going to change. So now they're in the process of getting a written decision together. But yes, I think the decision has been made. You redacted the Walter greeting. I know you both. Okay, so it was Walter. Okay. Yeah, Walter is, if you don't know him, Walter Knott is another attorney. He's in Florida, I think. And he is live streams a lot, has a lot of videos out there, very prolific. He and I have corresponded a little bit over the years. I think he knows what he's doing. And yeah, we have very different styles. So, he's a New Yorker, talks a little faster, and, is very opinionated about things, gets a little more political than I would. But, he certainly knows what he's doing. And I think anybody who is adding to the knowledge base of Social Security is a good thing. And so, I don't see other attorneys who do this as my competitors. They're my colleagues. And, if you can learn from him, from me, from anybody, you should do that. Rosa Gregory, feels so bad for me. No, it is a year to get approved for disability. Yeah, well, a year's good. If you got it done in a year, you're in good shape. It's really, it is tough, and it's, I don't know. I really don't know what to tell you. It's really tough. Um, any advice as to what will help you win your case, win the case along before you receive the funds? Okay. So Lady JJ's Self-Care and More says, what is going to help win at a hearing? And secondly, if you win at a case, how long will you receive the funds? So if you win, you get a favorable decision, you should see your money within 2 to 3 weeks, unless there's some red tape holdup. So, from 1 to 3 weeks, you should see your money. That's the easy part. As far as what helps you win, obviously, you have to have medical records that document a significant medical problem that is consistent with your complaints. In other words, if you have a bulging disc with no nerve impingement, but you claim that you cannot move because of pain, there's a disconnect there. So the medical needs to be consistent with what your complaints are. It needs to be a serious problem that would prevent you from being reliable at a job. Social Security is about work capacity, nothing more. So it's about your ability to be reliable at a job. So you've got to identify those things that would make you not reliable. I talked earlier about the theories of disability. You should have 1 or 2 or 3 theories of disability you can argue, or your lawyer can argue. Your age is going to be a really important factor. Much easier to win after age 50, even better after age 55. If you're under 50, big uphill battle. That's just the way it is. As I mentioned, you want to be very specific when talking about, how long you can, sit, stand, walk, lift, carry, kneel, crouch, crawl, walk stairs, all those things. Avoid not very much, not very far. You want to be very, very specific about those things. When the judge talks, you want to stop talking. Don't interrupt the judge. You want to show respect for the judge. I think a really important thing is to approach your disability case with an attitude that you're a fighter. Don't go in there saying, I've given up. I know I'm disabled. I need to get on, I really need the money. No, you want to go in there and say, I hate the idea of filing for disability. I would much rather be working. This has been miserable. As soon as I get better, I'm going to go back to work. You want to show that you are a fighter. I think, really the medical record needs to speak for itself, but I think you wanted to show yourself as a sincere, reluctant claimant who can speak very clearly about, the medical issues with very quantifiable terms. There are questions that you're always going to get asked, your past work. And again, if it's physical, sit, stand, lift, carry, things like that. So, think about those things. Have your lawyer go through them so that, you're not thinking about those things for the first time at your hearing. So I think those are some things that would really help you improve your chances at a win. But at the end of the day, all those things are great, but the medical has got to be strong enough to show that you have a condition that prevents you from being reliable at work. Okay, Laurie Schroeder, at least Laurie Schroeder, I'm sorry. Case was remanded by federal court. So Laurie had lost at a hearing, lost the appeals council, went to federal court. The federal court sent it back to the judge saying, here's some instructions to change this. She got asked 5 questions. Is this a good sign? Yes, it's a good sign, because as I've mentioned, people always ask me, well, if you're going to remand from federal court, are you going to win? And the answer is, some judges, recognize that the appeals federal court is not going to send a case back just for the sake of, of spinning your wheels, to ask the question a different way to get the same answer. They're kind of sending a message, approve this case. Many judges pick up on that. Some judges don't. Looks like your judge did. I think this is a good sign for you. Sweet Candy didn't have a hearing, did my adult function report. So I think you were saying Sweet Candy, I believe, said that, let me go back here if I can find it. I don't know, I can find it here, but I think you said just got denied. And I think I asked you, was this at a hearing or at administrative? So I think you're telling me it's administrative. So, what I would tell you is, if you just got denied, then you need to appeal. You have 60 days from the date of the denial to appeal. So I would say you go ahead and get that appeal filed. And if that's what you're asking me, and the adult function report, again, you may be asked to do that 3 or 4 times because it's taking so long. But you just have to keep doing it. I would make a copy of the original one and just update it. And you can do them actually if you type in the form number. I don't remember off the top of my head into your browser. You can do it online. Just type it out, which is even better because it's readable. So I would do that. Robert Loverso says he. Okay, not sure what that is, but okay. Leah T. Do you know any rules you can claim your adult parents on your income tax return SSDI? I don't know, Leah. I do not know about taxes, so I don't want to give you wrong advice about that. So I would talk to a CPA or a enrolled agent and just get some advice about that. I just don't know. Yeah, I think Price Joy, this is somebody asked what's good advice about the hearing. I think that's a really good way to put it. Answer the question completely and clearly, then shut up. That's kind of a abrupt way of putting it, but yeah, people sometimes want to ramble and tell their life story, and you can tell when judges get frustrated when they start interrupting you and say, "Okay, I appreciate that, but what happened back in 1987 is just not relevant to this." So yeah, I think that I think you want to answer the question clearly, then stop talking. Absolutely. Kevin Bogart. Okay, I don't know if I would go that far, Shub, but he had questions. Okay to ask questions. 3-part question. I get it, no problem. Haven't heard that term in a while. Bogarting it. Okay. Dan Nav from Facebook. I have friends being approved within months. I'm still waiting a year plus. Multiple physical problems at 55. People say this. Well, I know somebody who got approved in 3 or 4 months. Every case is going to be different. If you have a person who's got a terminal illness, metastatic cancer of some type, they're probably going to get approved early. Veterans, I've got a case coming up tomorrow. The person applied about less than a year ago, 100% disabled veteran. So, it's just going to depend on the circumstances. There are some cases that get expedited for whatever reason. We may not know the reasons. Again, 100% VA disabled is going to get expedited. Severe illness. In fact, I was looking this up for a video I'm working on about dire need and the circumstances for dire need, and one of them is shelter insecurity. You're about to lose you're about to be homeless, or food insecurity, medical insecurity, which of course is a lot of people. And one of them was, obviously a person who's on the compassionate allowance list or things like that. So it just depends on but it's because somebody else got early on. It's just because of something unique about their case, is my guess. Okay. Miracle after miracle is like Klein. Okay, well, I don't know who you are, but don't say. You can email me tomorrow. If SSDI onset of workers' comp in 22 changed to a later car accident with a payout method be offset by workers' comp. No, once the workers' comp, what you're asking me, I believe, is once the workers' comp settlement is done, okay, then that lump sum is paid, then the ongoing benefits stop. Where you run into trouble would be if you're alleging disability for a period of time that you're also getting weekly wage benefits from workers' comp. That's where you get the offset. Then once the case settles, the lump sum is divided out of your expected lifetime, no longer a problem anymore. So, in some situations, moving that onset date forward to after the workers' comp settled would be a positive thing, in the sense that you wouldn't have to deal with the offset at all. Something else, let me just throw out about workers' comp, and my wife does it, and it's a very adversarial area of the law. It does not play well with Social Security, again, because of these offsets. The other thing you have to be really careful about is many times in the settlement, you will assert that you will not file for Social Security for a certain number of months because the money that is being allocated to you in the comp settlement is supposed to be allocated to some degree towards your future medical care, which is Medicare, in Social Security terms. So Medicare does not want to be picking up payments for injuries that were on-the-job injuries. So if you have a Medicare set-aside, for example, in your comp settlement, you may have to agree to delay filing for Social Security for a certain number of months. just want to be aware of these things and talk to your comp lawyer and really get an understanding and make sure your Social Security lawyer has a copy of your comp settlement to make sure that there's no issues like that. Because what you don't want to have happen is to win Social Security and then apply to Medicare for a particular procedure or doctor visit, have them say, nope, not going to pay for it. This should have been covered by your comp. So that's what you got to be careful about. So Miracle, again, if you've got a comp settlement, send that to me so I can look at it. We can go over what that possibly means. Michael Robert Jennings has autism, has a hard time at part-time jobs, possibly get the disability CDR short form, always get the long form. You can get the short form because sometimes the short form will ask about work, but generally speaking, if they're seeing ongoing work attempts, they're going to send you the long form. Because look, there is a struggle in Social Security, with the way Congress designed it and the way Social Security administers it. On one hand, they want to encourage people to go back to work. On the other hand, they want people who have the capacity to work to get off disability. So there's that struggle. So on one hand, they want to encourage it. On the other hand, they don't want you to be intentionally suppressing your income so that you're making just enough to stay under the threshold to get your disability, but you could be making more if you just worked a little bit more. So there's that ongoing tension there. So my thought would be, if you've got ongoing part-time work that you can do with your autism, you're probably going to keep getting that long form, especially if you're younger. You say how old you are, but especially if you're in your 20s or 30s or even 40s. Okay, Luke says, if your case is very strong, but monthly benefits $1,000 for the claimant, what are the chances you take the case? I mean, again, if you think about, and look, I take a case, my goal is to get the case approved as quickly as possible. I have cases where I've gotten wins. I have a case right now where the case got approved at administrative level. I'm sorry, at the hearing level, went to a hearing. The judge changed the onset date to like 3 months ago or 4 months ago, right before the hearing. No past due benefits, no fee at all. And when I talk to my client, I'm like, look, you got to do what's best for you. I mean, yeah, I would like to get paid on this case, but at the end of the day, the risk, if you appeal, the risk could be you end up with nothing. You got to make that decision. So $1,000, cases now are taking 2 to 3 years. So theoretically, $36,000. If I'm paid 25% of that, that's perfectly acceptable to me. If your case happens to get approved early and my fee ends up being $300, then I say, write me a nice review. So that does not preclude me from taking a case. If it's a $300 or $400 a month that I'm fighting over, that might be something I want to look at. But I take some of those cases because, again, I feel an obligation. If I can help somebody win and I can win quickly, I'm going to do that. But yeah, I would not turn a case down because the benefit amount is $1,000. There's usually going to be enough to make it worth my while. And like I said, if it turns out that I get paid very little and I get a nice review out of it, I'm cool. I don't want to lose money on cases, but I suspect with that I wouldn't lose money on a case. Christina says hello from California. Hello, Christina. St. Louis says every job outside of self-employment requires some interaction with management. I think so. I think there's going to be some interaction. There was an interesting thread I was reading on the listserv that I'm on, and one of the attorneys made the point that even if there's a job that requires no interaction with coworkers or supervisors, and there are some, there's going to be a training period where you do have interaction with them. So, I think that, there are jobs that once you are trained on them, you can do on your own without interacting with anybody. For example, let's say that you're a driver and just throwing this out, and you pick up, medical samples from doctors' offices after hours. They put a test tube full of blood or full of whatever, one of those locked boxes you see in a doctor's office, and your job is at 7:00 at night to go around and pick those up and deliver them someplace. You're not going to interact with anybody. So, there are jobs where you can have almost no interaction with anybody. So I think vocationally, a vocational witness can identify some jobs that will have no interaction with anybody except for the initial training period. So, one could make that argument at a hearing that there's no jobs that wouldn't have some training, but a judge might say, well, after the training, there's no interaction. Are there jobs? They're not a lot of them, but there are a few. So I don't think that's an accurate statement that there's always going to be interaction with management. Um, you know, you can have very, very incidental interaction. I mean, yeah, certainly, if you're working for somebody, there could be some incidental, but again, I don't think that, you know, a unless you have it's PTSD or something where literally you cannot interact with anybody and there's medical support for that. Yes, if you have evidence you cannot interact with anybody at all, you must be either all by yourself or with your spouse or with your parents, and that's it. If you can get that I think would preclude all employment. I would agree with that. But I think that's going to be really hard to get. But it could be. But vocationally, a judge can frame a question where interaction is so minimal that it would really not preclude most people unless they have a blanket 100% no interaction, which I think, again, is going to be hard to get. I hope that answers your question. Um, Carolyn says, I missed you last few lives. Well, I'm sorry you're back in the hospital. We missed you, Carolyn, for not being here. I'm glad you're back, but you're back in the hospital with a spinal leak. That's not good. So much going on. It scares me, the new application. Yeah, I get that. I mean, I think it is this CSF leak is not a good thing, obviously. Hopefully they can get that patched because that is not a good thing at all. Yeah, it's a scary time. It's a really, really scary time. Um, again, we don't know. There's just a lot we don't know, and there's just stuff that's coming out, and things just sort of happen. And I think that a lot of the people, that are obviously, Mr. Trump and Mr. Musk have a vision for, they perceive there's a lot of fraud in Social Security, and they think that there's needs to be a lot of changes, and there's a lot of dead weight at the top, which I don't necessarily disagree with him on that part of it. But getting rid of all these people is going to cause a lot of hardship and a lot of delay. Um, I don't know that the opposition to that has really firmed up. I think that people are moving so fast that nobody knows what's coming next. And politically, Social Security disability claimants are um, not a unique voting bloc, and so it's not like that there's lobbyists for people who are pursuing disability. So yeah, we're going to see. It's going to be really, really interesting to see what happens. Again, one of the things I saw the other day was that um, Mr. Trump feels that he has the right to fire administrative law judges for any reason whatsoever, which could be ideological reasons. So, again, they could appoint people that are, basically of the opinion that unless you are in death's door, you're not disabled. Has not happened yet, but we'll see. Now, typically, when people try to do that, when executives try to appoint people, and this holds true with the Supreme Court as well, they don't always get what they want. And, judges are going to tend to be a little more independent of that. But we're just going to have to see. I mean, I hope that wiser heads prevail. There are people, obviously, a lot of people that, of course, I deal with that are legitimately unable to work. They've got significant medical problems. And I hope that, our administration and the people at Social Security realize that those people legitimately need help and will help them. So let's hope that happens, but we'll keep an eye on it. And certainly, if we start seeing things change one way or the other, positive or negative, I'll let you know. Look, we had a positive change in that Social Security changed the rules that said that every case had to be reviewed by a medical specialist. They said now, at initial recon, the adjudicator can make a decision without going through the medical specialist if they don't have enough medical specialists available to them. So that was a positive. They changed the look back for jobs from 15 years to 5 years. That is a positive. That helps us. So there are some positive things going on as well as some not so positive things going on, the delay being the big one. So we're just going to have to see. We're just going to have to see. Robert, okay, so checking in from Arizona, you were in the hospital. Okay, good to see. Well, I hope that you're out of the hospital, Robert. Never good to be in the hospital for any reason, but thanks for checking in, and I hope that you are recovering from your hospital stay because um, I have not been in the hospital for many many years, but I visited people there. Just one observation I make is they're constantly taking your blood pressure, your temperature, you're taking blood. How do you get any sleep? I mean, it's just like how do you sleep? This noise, beeping, all this stuff. It just doesn't seem to be very comfortable. I don't know. Um, Michael Robert Jennings, can Social Security consider multiple impairments to the initial, or must every impairment stand on its own initial to see if the listing is met? Very good question. They can consider multiple impairments. That is the functional capacity theory of disability, and they can consider not just one thing to meet a listing. And look, they don't have to. I'm clear on this. At initial or recon, a listing is the most common reason people get approved. They can approve people under functional capacity or grid rules as well. So they're not limited to just looking at the listing. But to answer your question, they can look at the combined effect of things just like a judge can. It's just the difference is an adjudicator doesn't have quite the same discretion as a judge would have. Again, they've got to talk to a medical person. They've got certain assumptions they can't make. But otherwise, they can do they can approve a case under any theory of disability. Christina says, please do not forget to like, share, and live stream. Thank you very much, Christina. I appreciate that. And I'm going to put here in the crawl place, if you wanted to leave me a review, you can do that, which I really appreciate. But yeah, if you let people know about this, I mean, I'm trying to, obviously, we're getting around 200 people every week. Like to get that up, obviously. Love the questions. This is a lot of fun for me because I get to interact with people, just on a one-on-one basis, even though it's in a kind of a group chat. But it's a good way for me to share what I know, which I like to do. I do it on the videos, but this is a little bit more immediate. And it's also, it gives me a chance to bring on some people that I can learn from. Like we had Adriana De La Torre, who's an appeals lawyer. She came on a couple weeks ago. It's just I learned a lot from that, so it's very helpful for me as well. Okay. Okay, Jim asked a very good question. When contacting your representative, does it matter if you're a congressman or senator for help? I personally go with the senators because they're in for 6 years. They have bigger staffs. I think they're, probably going to be able to be more effective. You get a letter from a senator, it's going to just carry a little more weight than a representative. If you happen to know a representative or you feel that your representative is particularly responsive to you, go that route. If you try the senator and it doesn't work, you can do the rep. I think both are good, but my personal preference is a senator because I think, Social Security gets a letter from a senator. There's only 100 of them. They get a letter from a senator. It tends to, make them stop and think. They get a letter from a representative that they never heard of, may not be as much. So that's my take. But again, if you have a relationship with a representative, go that route. Jen from Nebraska. Jen, we had somebody from Deb, I believe, was from Iowa, telling us that she had snow. It was like 70 degrees or 60 degrees a couple of days ago. This morning it was 7 inches of snow and 28 degrees. I think you sent us a screenshot of your weather app, and it showed like 28 degrees or something like that. So I'm guessing you're getting kind of the same weather they get in Iowa, which is, as I said to Deb, why one lives in, where it's going to be snowing in late March. I don't know, but it is what it is. We got to, Jen, it's interesting. Jen and I have been working together for several years. We've never met in person. It's all over the phone or by video. And so I told her one of these days I got to get her down to world headquarters here at Ginsberg Law Offices. But I mean, all of my staff now is remote, and of all the people that I've worked with me now, I have met in person 2 of them. One of whom I first met, Stephanie, who works for me doing drafting appeals. Her mother was my paralegal many years ago, and I knew Stephanie when she was in high school. When she was would come by the office, to see her mom. So now she's all grown up, and she became a paralegal, and she's doing some work with me. So I know I met her obviously through her mom years ago, and then I have another person, Darlene, who I literally know, I see on a somewhat regular basis. But everybody else is all remote; they're all virtual. So I see them on the video, but we've never met in person. So Jen, one of these days we'll have to get you down to World Headquarters. Okay. Um, the Crooked Dog Ranch. Is it the crooked dog because the dog is crooked, or is the dog not honest? That's really my question when I see Crooked Dog Ranch. I'm 60 on SSDI for 30 years. Okay, was thinking of doing a work attempt truck driving to try to finish out at 67 with some cash. Is this a dumb idea? To be happy I make $2,000 a month. Is this dumb? um, I think that it's 60. The odds of having a review for medical improvement are not huge. Anytime you work, you run a little bit of a risk that they may look at it and say, well, now you've got medical improvement. If you stay below SGA, which is $1,620, I don't think it's going to be a huge issue. I tell people, keep in mind that you've got the trial work period. You have 9 of those. So the first 9 months you can work, you can make as much as you want, unless you've already used those up. So that certainly would not be a problem. Then after you've used up your trial work period months, if you stay below SGA, which again is $1,620 a month gross. So if you got $1,300, $1,200, I don't think it would be a huge problem, especially at 60. Is there a little risk? Yes, you got to just weigh the risk versus the benefit of having that extra $1,000 a month. Is it worth it? Yeah. Kirill, thank you. I'm glad my answer was good. I dropped weight. I wish. I'm trying. What I'm trying to do is cut the carbs. I mean, it's so hard. It's just so hard. I mean, I really just pretzels and popcorn, all that kind of stuff. And so I was reading a book. Actually, it's a very interesting book by this guy named Gary Taubes, Taubes. It's called Why We Get Fat. And I'm in decent shape. I play tennis several times a week and walk the dog. And, I'm 10, 15 pounds more than I really need to be. But, not terrible. But he makes the point that, and there's a biochemical, and I won't bore you with the details, but the big picture is that what carbs do is they cause your insulin to spike. And when your insulin spikes, it blocks the body from releasing stored fat. So, when insulin spikes and goes down, the body thinks it's starving. So it's going to, it makes you hungry again. So really, in his view, and I think there's research to back it up, it's all about the carbs, You got to cut the carbs. I have another friend of mine I play tennis with who is a nutrition professor at Emory. And he said he's a big believer in just having a lot of small meals, eat every 2 to 3 hours, because that keeps your insulin, again, the insulin, keeps your insulin level. You don't have these spikes where you get terribly hungry. It's just because human beings evolved to, store energy when they had food available, to eat as much as they could and store it as fat because they weren't eating, every day. They were eating every 3 or 4 days, if they could find food or if they killed a buffalo or something like that. So he's like, keep your insulin steady by eating small meals in the day. And again, Gary Taubes says, avoid the processed carbs so you don't get the spikes. So I think that's what I've been trying to do. I really know how successful I've been, but I'm really trying to avoid just the pretzels and the popcorn. And like, for example, today I had a sandwich, which is, bread I shouldn't be eating, but, not too terribly much. Instead of chips, I had some peanuts. I had a salad for dinner with no carbs, just salad. I mean, obviously lettuce has got carbs, but, no croutons, no, chips, anything with it. So yeah, that's what I'm trying to do. So hopefully now that it's getting a little warmer, I can get a little more exercise and I can, drop the part of it that I need to get going. But thank you for noticing. My wife would tell you you're crazy because she doesn't think I have, but, maybe a little bit. I'm trying. Okay. Blue Z, don't want to sound stupid. Prior to going to post review status, the judge pretty much made it. Yeah, I think that, and Blue Z was early on asked, my file shows the cases in, post review status or something, or hearing review, evidence review. Yeah, the judge, I would say 95% has made his decision. And then it goes to the decision writer. I don't know what percentage, probably a very small percentage of the cases are changed at that point if the decision writer feels the judge made a terrible mistake, or something new comes in that makes the judge change his or her mind. But more likely than not, the decision has been made at this point. It was made immediately after the hearing, is what I'm going to tell you. Cami Loomis. For those who work in education or work in education, how does it overturn the windfall elimination help? The state does not pay SSA. I think what it does, and I don't know much about it honestly, is that I believe it eliminates the penalty that would help people who are getting one type of retirement also get Social Security. But you know what? I don't know enough about it to really say. So as Canny says, anybody who's in education who's experienced with this maybe can chime in for us. Angie says, if we waive the 75-day notice to speed it up as far as getting a hearing scheduled, it can. It doesn't always, but it can. I think that if you're ready to go, waive the notice, and that way I've had cases, I think I mentioned last week, I got a call from a judge's hearing assistant saying, we have an opening here. Will you take it? It's in 3 weeks. Yep, I'll take it. And, I need you to waive the 75 days, consider it done. So, yeah, I think that that would probably speed up getting a hearing scheduled. Yes. That's not, okay. I think you're responding to the gentleman who was thinking about going to Crooked Dog. No, it's not a stupid question at all. Blue Z. There are two people who basically said it's just dumb or it's just stupid. No, there's no, look, there's everything you do in a Social Security case, there is risk involved. If you apply, okay, the risk is you may wait 2 to 3 years and get Zippo. You may get nothing. If you get approved and they change the onset date and you appeal, there's risk that you could be denied. Not a great risk, but it could happen. If you have been approved and you go to trial work period, that could possibly, at some point trigger a continuing review. If you're on disability and you go to work and you're below SGA, that could possibly trigger a review. There's always going to be trade-offs. So you've got to make a decision, is $1,000 a month worth the small added risk? For a 60-year-old who's been on disability for 30 years, the risk is not great in my opinion. It's not a very big risk, but there is some risk, So I just, anything that you have to make a decision on, there's always going to be another choice. Somebody asked, I'm not sure if it was on the live stream or on an email to me. I think it was maybe an email that the doctor said, I think it was on the live stream. The doctor said, you can do surgery. I don't remember where, I shouldn't want to say. Doctors basically said, I can offer you surgery or you can stay in pain management, but I can't offer you any guarantees. Well, what do? Do you take the surgery or do you take the pain management? It's just a judgment call. You got to make a decision. So I think what I said to the gentleman was, contact some comp lawyers and get some different opinions about the legitimacy of the surgery and whether it makes any sense. But yeah, everything's a trade-off. Laurie Schroeder. I think I already answered this question. That I think it is a good sign. Is it true the post-hearing review they pull back? The decision writer will, yes. The decision writer will play back the hearing recording. That is what will happen. Scary time to file severe stenosis in 2 places. Issues from T6 to S1. MRI last week, doctor. Or surgeon already fused L4-5. Shell part 2. MRI this week, both shoulder severe tears, knee replacements, sleep apnea, currently work. I try to hide my part 3 pain and discomfort, fall asleep at work, have a vacay sick day, so I usually was best leaving a job, fall asleep. Okay. I think, Michelle, one question you didn't say, how old are you? Because you've got significant medical issues here. Um, and, if you're over 50 or over 55, I think, just on what you tell me here, this looks like a pretty strong case. If you're 35, it's still a good case, but it's going to be harder. So, the answer to your last question would be, should you leave your job and file SAP if you have vacation, sick time? Um, I would make sure you get that, whether you get it as a payment or after you stop. I mean, some jobs will pay you out your accrued vacation and sick time. If your job will do that and you decide to stop, you get a lump sum of money. That's a good thing. But if you're not sure about that, obviously you should just take your time, take your vacation time, get paid, and then stop after that. So I can't really answer the timing as far as when you should stop. It's going to really depend on what your company's policies are. But and also, like I said, how old you are. If you tell me that, I could give you a little more insight as to what you might want to think about doing here. But I think on its face, the medical issues you've got logically will give rise to significant problems that would be work preclusive. All right, so E.O. Young says, are they shutting down phone conferences or making us get SSI if we're disabled? No. Right now, well, again, just to give you a little history, before COVID, all hearings, almost without exception, were done live, in person. So you would have to go to a hearing office. During COVID, they stopped all that. No in-person hearings for a couple of years. And they created a telephone hearing system and then eventually a video hearing system. And it was so well received, they made that the default. Now you can, that's the default. You can opt in for a live hearing. Not a lot of people do it, but you can do it. So some lawyers feel there's value to it. I personally don't. Some claimants want to see a judge in person. That's fine. Again, to me, virtual hearings are the way to go. But there's no talk about changing that that I've heard of. And in fact, I've heard the exact opposite. They want to make it because, again, it's just going to be, much easier to get through the backlog to have virtual hearings. The judges may have to sometimes go in, although, again, they entered into a contract before, the current administration that gave them the right to work remotely. So I think there's a battle going on, but my understanding is the judges are still working remotely. So, at this point in time, and I'm recording this March 19th of 25, there will not be any, there's no going back to all in-person hearings. I think they would be very, very unpopular if they did that. And I'll give you a simple reason. I mean, when I used to do live hearings, and I'm in Atlanta, Georgia, big city, I would have to drive down to the Atlanta downtown hearing office, which is 45 minutes drive, or take MARTA, which is the light rail, which would be an hour and a half. If I drove, I'd have to park. It would be $25 to park, and then I would use up a good part of my day for one hearing. Now I can do a hearing in a t-shirt and shorts by phone, and do one in California in the morning, one in New York in the morning, California in the afternoon. Much more efficient for everybody. Judges like it because they're not in a room with people hacking and coughing. So a lot of positives to it. Again, we'll see if there's any changes with that. But to my knowledge, there's not going to be anything, any change there. And again, if you think about it, as a claimant, do you want to really drive to some downtown area that you're not familiar with and pay $25 in parking when you've been out of work for 2 years? It just doesn't make any sense for anybody. So I think that what they're talking about is that for people at retirement age, if you want to change your direct deposit, and this is what this is all about, is there's a perception that people are going to calling Social Security, changing direct deposit information and stealing Social Security money. And so what the options would be is you've got to go online and you've got to upload, identification like your driver's license or passport or something like that. And if you can't do that, you've got to come in and to a local office and provide that information before they'll change the direct deposit information. That's what they're really concerned about. And the outrage is that there are people, 80-year-old grandmas who don't know how to upload anything. They're not computer literate, and they don't have the ability to, to go to an office 100 miles away. That's what the problem is. And I will tell you that, Social Security has made a real effort to make more of the applications online. It's right now, I don't think you can even get through it and make a phone application. So I think that, it's pretty much online or, you know, in person, which again is really, really hard to do. And a lot of entities, I mean, I'll give you an example. I had to file a business license for my law firm the other day, and I had to, basically get a document notarized that basically, said I documented that I'm, in resident as a citizen of the United States, all this stuff. I had to upload a copy of or attach a copy of my driver's license. So it's not that unusual for, banks, for government agencies to require proof of identity, because there's a lot of identity theft out there. And what Social Security does not want to be in the middle of is somebody calls up and says, I'm now at Bank of America, here's my number. And, it wasn't correct. And then, grandma finds out, 3 months in, I'm not getting my check anymore. And she finally gets through it. Oh, you changed your bank. No, I didn't. And now we got a big mess. So I think they're trying to be proactive on that. How big of a problem it is, don't really know. But I mean, they seem to think, at least the Musk folks seem to think it is a huge problem or could be a huge problem. Identity theft is a problem. Um, but is this the best solution? I don't know. I don't know. And I suspect what we may find is there'll be like these mailboxes in more places. You'll find other, small companies that will be available, just like you can now go to various places to get your, what do they call it? The when you drawing a blank on it, when you travel, you have, if you want to get your number so that you can skip the line. I can't remember what that's called, but you can go now to different places and get that done. Not frequent flyer, but known traveler number, whatever. So you can avoid those lines. So pre-check, TSA pre-check is what I'm talking about. That's what I'm thinking about. Yeah, you can get your TSA pre-check. It doesn't have to be at the airport now, so it can be other places. So I think what will happen is if they make this requirement into law where you have to go in person, you have to have documents to do your change of bank account or establish a bank account for payments, that there'll be vendors like a Mailbox and More, Kinko's, those kind of places that will do it, or libraries will do it. So, everybody's saying that the sky's going to fall because now grandma can't get to an office 100 miles away. Yeah, I'm not sure that's going to really be the case. Was this rolled out in a very diplomatic way? No. But inherently, trying to avoid fraud with Social Security money is not a bad thing. It's just, I think what they're doing, some of the stuff they're doing, it's just not being done in a very diplomatic or logical way, in my opinion. But some of the concepts, of getting rid of some of the fat at the top and, ensuring that money is going to the right place, that does make sense, in my opinion, at least. Okay. What would be my grid rule for rheumatoid arthritis, osteoarthritis, cervical stenosis, and IBS? Well, again, it depends on your age, because the grid rules, if you're 50 to 54 in 12 months, you're going to look at the sedentary grids. And if you are 55 and over, you're going to look at the light grids. And basically, the grid's going to also depend on your education, your work experience, that sort of thing. So it could, if you have no education at all, that's going to be one grid. If less than high school, another one, high school or more, something else. So it's got to be a physical limitation. So RA could be physical limitation, osteo could be a physical limitation, stenosis, IBS probably won't be a physical limitation. So I think it's going to probably be the first three, the RA, the arthritis, and the stenosis would probably limit you to either sedentary or light. So if you're over 55, look at 202.06. If you're 50, look at 201.06. I use those a lot, but it's just going to depend on some of those other factors there. And of course, your past work. Stacy Smith says, hubby denied twice, had 7 neck and 6 low back surgeries. Something delete to infections and failure. Last one ended with loss of his hands. Damn. Some back after 4. Loss use of his hands, some back after 4 months rehab, no idiopathic syncope, which means passing out, help hearing paperwork. Um, yeah, I mean, he's been denied an initial recon. I think that's a pretty good case. I mean, I would look at that one because sounds like he's a mess. Um, yeah, he's got a lot of stuff going on. I think there's enough there, at least in my opinion, based on what you're telling me. Um, so if you haven't, so again, let me put the crawl here. Um, if you don't have an attorney, call me because I think that sounds like a pretty good case. Um, okay, Pricey Joy took her over a year. Yeah, it's hard. They make it hard. If you're over 50, what's the rule for past work? How they go back? Well, again, everybody goes back. I mean, right now, Social Security goes back 5 years. So from the date of the hearing. So if you have a hearing in March of 25, they're going to go back to 2020. And anything before that does not count as past relevant work. Logically, the reason is because any skills you may have acquired from a job you did 7 or 10 years ago, that job has probably changed in the last 10 years. So it's not relevant. And so that's why they don't use it anymore. But it doesn't, whether you're over 50 or under 50, they still are only going back 5 years. Jim says, why did SSA request? No, my legal representative has been an SSA for 3 years. Request made through online site. The only thing I can think of would be that if you are represented, they're not supposed to talk to you without getting permission of their rep. So maybe they want to see if you're still represented. And if so, they need to contact your rep to say, is it okay to talk to Jim? That's the reason they would ask. Okay. Oh, Potts was I was thinking about the person with Ehlers-Danlos. That's what goes along with Ehlers-Danlos. Yeah, 3 years. No, I think he's got a strong case, Stacy. I really, based on what you're telling me. That's very sad. I mean, you can see how health can really turn and go bad. Sorry to hear that. At Roy's place, got a letter asking if you've worked and you didn't, and show what the checks were for. Employment law settlement is offset my benefits. No, not for SSDI. No, don't be concerned. If it's SSI, it can be a problem. At SSDI, no. Once you provide the information to them, you should be just fine. Don't worry. I can't tell you not to worry about it, but there's no offset there. You would not have a problem because it's a settlement. It's not for work performed. Dwayne Lassiter on SSDI, and June will be at full retirement age. Will they transfer? They will do so. And yeah, again, I don't know all the rules, but I believe once you're on retirement, you can work without penalty. Again, I'm not a retirement Social Security expert, so just you have to make your own decision on that or do your own research on that. But it'll automatically transfer at full retirement age, so you'll be able to deal with whatever advantages come to someone who's on retirement versus disability. Spring Blossom. If I file electronically at 60, is there an electronic edit to pull my SSD application with attached medical records for a QDD, quick disability determination? If you file electronically, I mean, what Social Security is doing now is they are using something called a HIT, Health Information Technology, to request medical records. So when you apply, you want to list all your medical providers, and if the medical provider is part of HIT, they will automatically request it that way. Otherwise, you need to make sure the addresses are accurate as far as the providers, so that they can get all those records. But yeah, I think that the more complete information you can give them, the better. But they will pull. It's not like an electronic edit, but they will use health information technology to download records immediately from a number of different hospitals and large practices. But I just to stress, I don't want to under stress this. It's really important when you fill an application. If you have, let's say, 10 doctors, take a few minutes, look up the doctor's address, call the doctor's office. What is the mailing address for someone to request medical records? Use that address. Make the life of the adjudicator easier. Don't make them fight to try to find the doctor's address. Heidi E. 21-year-old autism with low IQ since age 5. Part-time with health accommodation, reduced low IQ. Autism. a good case. Um, I think, medically, you know, assuming that all these things are documented and that you've got a psychiatrist who's willing to sort of make a work determination that this is limiting you work wise, you don't win on a diagnosis. Okay, so having autism, having low IQ, those are factors, but they do not mean you are disabled. For education doesn't mean you're disabled. Heavy accommodations does tell you something there. Um, uh, Disorganized thought and paranoid schizophrenia, again, that's a diagnosis. You need somebody to say what that means in terms of your work capacity. And so if your psychiatrist would fill out a functional capacity form, that would be really, really helpful. Or a statement on the listing, that would be very, very helpful. I would assume, now the other thing you need to look at is get your My Social Security Statement, SSD, ssa.gov/my account. Even though you're 21, if you've worked, maybe you've got enough credits for SSDI. Maybe you're pretty close to that. So, if you could get enough credits for SSDI as opposed to SSI, that would really be to your benefit. So my point is that maybe in certain circumstances, if you could figure out a way to work for another couple of years, that might get you insured for disability. A lot of things I'm not throwing at you, but right now I'm guessing you're SSI only. And SSI, in my opinion, kind of traps you into poverty because you can't really try, anything you try to do, it punishes you. So if you could get on SSDI, that would be a lot better. Okay, so K. Patrick tells Austin Vibe, was asking about what the supplemental hearing. This is the ruling that I think changes to the 5-year look back. Madeline, I referred to you earlier. She is one of my paralegals case screeners, and she pops on usually on these live streams. So hello, Madeline. In Oklahoma, I mentioned all the other states, and I mentioned Madeline in Oklahoma. So I hope that she's doing well. How's weather, Madeline, in Oklahoma? People are telling me in Iowa it's snowing, and we know that Jen says in Nebraska it's freezing cold. It's 75 degrees here in Atlanta. So, depending on where you're at, I guess is how the weather is. James is 38 years old. Okay, if DDS wants physical mental health records from 18 to 22 years old, doctors are retired, who do I contact? You can't. I mean, unless the doctor sold his practice, it's going to be really hard to get those. There's no repository for those records. So I don't have an answer for you. There's no way to get them. Unfortunately, if you could, maybe the doctor could give you a narrative that described what he did for those years or she did for those years. What I would probably tell you to do is see if you can find out whether a doctor's sold his. Many doctors, when they retire, they'll join with another practice, and that practice maybe has a different name, but those records may be in storage someplace. So maybe there's a way to get them, but you got to find out what happened to the doctor and what he did with his practice when he retired, he or she. Beth Evans was hit by a drunk driver at 19, 53, 47 surgeries. My goodness. Denied 3 times. Go before the judge. Yeah, go before the judge. I mean, 47 surgeries. Remember I said earlier that the big issue, when you're looking at the medical is, does the medical record, is it consistent? The procedures, the diagnoses, is that consistent with your subjective complaints? So, like I said, if you have a mildly bulging disc, but you're complaining of pain at level 9, 24/7, doesn't make any sense. It's not consistent. You had 47 surgeries. You sound like Evel Knievel, if you know who that is. You're going to be in pain. Yeah, I think a judge is going to be, especially if a former ENT, you tried to work. I think a judge is going to be, most judges will be pretty sympathetic to that, assuming that your records are consistent with a significant level of pain. Okay. Okay. So Deb says in Iowa says 2 consecutive Wednesdays of these snowstorms after 2 previous days, upper 60s. Well, hopefully you're finally getting rid of all this cold weather. That's crazy. Michelle, does everyone go to a hearing? Some get approved immediately. You can get approved at initial or recon, and you can get approved sometimes before a hearing. A judge could grant your case on the record, so they could approve it at any stage of the game. Early, sometimes they do. I'd say, I probably would tell you every 2 weeks, I get an approval early, initial recon. So it's not unusual at all. Can I collect retirement while going for your dip? Yes, you can. Absolutely, you can do that. Like I said, when you do that, you get the lower amount, the discount right away, and then you're going for the difference between the two, early and discount. And if you win, they bump you up. If you lose, you're stuck at the lower figure. But you can. How can make how can you make them pay you? Okay, Kenneth says, how can you make Social Security pay you your retroactive payment after an 8-month waiting period? Um, I need a little more context, Kenneth. The waiting period is 5 months. It's a 5-month waiting period, 5 full months. And then after that, if you were deemed disabled and the 5-month ran and you're entitled to 8 more months or 3 more months, whatever, they're supposed to pay you. If they're not paying you, there's a reason for it. And the question is, what is the reason? So I need a little more context, and hopefully I can answer that. How far back does SSA pay? 1 year prior to the date of your application. 1 year prior to the date of your application. So if you, regardless of your onset, so if you applied in March of 2024, you can get paid. Earliest would be March of 2023. Now, if your onset date is March of 23, the 5-month waiting period would run. You wouldn't get those 5 months, and there would be, August or September, whatever, of 23 would be your first payment. But in terms of if your 5-month waiting period ran 4 years ago, and then now you get approved, you would get approved 1 year prior to the date of application. Diogenes, can I win my hearing pro se without knowing what's in the blue book? You can. I mean, the blue book is one theory of disability. In fact, that's not the one that you're probably going to get approved on. It's pretty rare, actually. I would know the grid rules. I know functional capacity more. I'm not a big fan of doing hearings pro se, just because I think you're not going to know. It's going to go really quickly. You're not going to know how to cross-examine the VE. You're not going to know, what necessarily the judge is wanting. But there's nothing that says you can't. Realize if you hire an attorney or non-attorney rep, there's no fee unless you win. So it doesn't cost you anything to hire an attorney. And, yes, you give up 25% of your past due benefits, but 100% of zero is still zero. So, that's my take on it. But you don't have to have an attorney. And you can argue anything an attorney would argue. Having a terrible time. Federal quality control sent it back for re-adjudication. Probability of reversal of the denial, and she denied days. She got it back. Not really sure what you're asking me. That maybe it went back from quality control. I don't. I'm sorry, Jen. I don't know what you're asking. I just don't understand it. All right, Beth is in Panama City, Florida. Been to Panama. Actually, we go sometimes to the seaside area, which is not too far from Panama City, on the Gulf Coast, and it's very, very nice there. In fact, Stephanie, one of my assistants, lives not too far from there. So Panama City is nice. Some of it's a little honky tonk, but some of it's really nice. So a nice place to live, and other than the hurricanes, it's great weather. Okay, Deb, response to Michelle about certain cases that get approved early. Rick says to Dan, I'm on 3-year waiting. Yeah, that's crazy. That's crazy. Crazy. Way too long. Lucky was 58 when he applied. And still an initial at 59 and a half. When will they apply age 60 for my case with the recon? Will the judge use that? Well, realize that, the grid rule begins to apply at age 55. Is it possible that they could approve you as of 60? Yeah, but it's not I don't see that. I mean, the big difference between 55 and 60 is there's something called the POMS, or Program Operation Manual, which really talks about that. This POMS section talks about past relevant work. And At 60, basically, Social Security would have to prove that you would have to make what they call minimum vocational adjustment. Um, at 59, they wouldn't have to prove, but it's not that big of a difference. So I don't think that that's where they're going to do. I think that the bigger problem I've seen is people who apply at 49 get approved at 50 years and 4 months. They move to their 50th birthday, or they're 54 and a half and they get approved at 55 and 3 months and they get moved to their 55th birthday. I don't see it from the 55 to 60. Doesn't mean it couldn't happen, but I don't see that. So I don't think that's what they're doing. I think that more likely than not, you'll be treated as a 55 plus person. Esoteric is our person with who comes every week as a TBI says, yes, a year is very quick. Can my attorney still bill me if I get denied after appeal recon and not proceed to hearing stage, given zero award to pay legal? I mean, theoretically, an attorney can file a fee petition, whether he wins or loses, or she wins or loses, but they have to collect from you. If you have nothing, I don't do that. I mean, I don't think that. Now the attorney could ask you for file expenses if he had to come out of pocket for medical records or things like that. But it's pretty rare for an attorney to file a fee petition for someone who either decides not to proceed or gets denied and loses and doesn't appeal. It's pretty rare, but they can file a fee petition, yes. But if they get it, there's no past due benefits, so they're going to have to collect from you. And presumably, if you're not working, you don't really have much to get from. So it's kind of a waste of time for an attorney to do it, in my opinion. How many hours do we get per question? Hopefully not more than 2, because I'm only on for 2. Wish me luck. My appeal's coming up very soon. Hope my attorney's prepared. 62-year-old nurse, very anxious. 62 is a good thing. I mean, in the sense that it's easier to win at 62 than it would be at 42. So that's cool. I wish you well. April Holmes, thank you very much. I will. Okay, Sadie, my fur baby is a 5-year-old Sadie. She is a 75-pound golden doodle, and I appreciate that, and she appreciates that, and she loves treats, that's for sure. But we find her stomach sometimes is not so good with certain treats, so we limit I get the Costco dog biscuits sit pretty well with her, so I'll get those for her. Sometimes I'll get something like at dog pet specialty store, but we try to limit her to things that are easy on her stomach, because doodles are known for having kind of sensitive stomachs. But I will definitely get her something, and thank you very much for that. Much appreciated. Okay, so we are getting about 10 minutes to go. I'm a non-ERISA Oregon school teacher. I'm waiting to see if I'm approved or not. I've been waiting hoping every day. Okay. Yeah, I mean, 130 days is unfortunately kind of that's on the low end. So it could be a while. I hope you get approved, but if not, appeal. Definitely appeal. My pleasure. I'm glad to answer questions. That's why I come on. I like to do it. If you're on disability since 2003 at a 4 CDR medical group of 55 with a possibility of getting another CDR of 63, I think it's pretty small. I cannot believe they would be wasting their time going after you. I just don't think it's really, really high. If the district court is not remand, can my attorney continue to climb the federal ladder? Yeah, I mean, I think that they can go to circuit court, but I mean, that's, it's got to be something pretty significant. And when you get to that level, the circuit court has to agree to take the case. It's something called certiorari, I believe. They've got to agree to take the case, so it's not as of right. They have to agree to take it. Remanded now, I think the last thing I saw was of the cases that were taken to federal court, about half of them were remanded. Now, again, not every case goes to federal court. Not every attorney who does federal court work will take every case, but the ones they take, and these are people like Adriana who really know what they're doing, they're probably pretty good arguments. So half of those get remanded. So it's pretty high percentage. Can I apply for SSD if my work credits expired and how to get approved denied? No, that's the problem. If you work credits have expired and you had a hearing decision after that date, you can appeal the hearing decision, but if you start a new case, you're no longer an SSD. You have to go SSI only, or you could try to work for 2 or 3 years and get those credits back. But no, once it goes, it goes. So just so your workers' comp, you need to check. You need to check to see if there's Hartman language in there. I would talk to your comp lawyer. I definitely would do that. Let's see here. Okay, Christina says, please do not get out. I'll take this call down, but yeah, please leave me a review. If you find this helpful, I would really appreciate it. That would be much, much appreciated. Okay. Francis Harrison. My husband applied over a year ago for SSDI. Just sent to see one of their doctors in the third of the month. How much longer? That report will be in pretty quickly. I would tell you 3, 4, 5 months. That's what I would tell you. That's just what it's going to take, at least. Okay, let's see. I won't. I know there's some questions going on about Oregon and California and teachers and so forth. So I don't need to answer those. If I was to get approved for SSI and my spouse and SSI were married but have been separated, now we live with the sister, there's going to be money bill. I don't think so, but I don't know enough about the deeming rules in SSI cases. This might be a case for Greg to let me see if I can get his email address. Greg Brinkley, Greg at gregbrinkley.org. Let me just put this in here. Check with Greg. I just put his email address in the chat. So if you want to have questions about SSI and deeming rules, I would check with Greg. He might be able to help you. Greg at gregbrinkley.org. Okay, so far most of them, they won't be touching them. Well, we'll see. We'll see. Okay. I have a side conversation going on about employer-paid disability plans and so forth for our teachers. Okay. Joe Minnick. I have MS. I'm under review. I've been to a doctor in 3 years, but MRI 3 years. Okay. When you say you're under review, I'm not sure if you mean you're applying for disability or you're being reviewed after already being on. I'm assuming you're trying to get approved, so that means you're not yet approved. I personally would tell you that an MRI, that I would be more comfortable with an MRI that is more recent than 3 years ago. MS obviously does not just go away. So, and if it was a disabling level 3 years ago, probably still disabling, but I think judges would be more comfortable having something a little more current. That's just my take. Laurie is 66, had a fusion due to severe scoliosis, having back issues, other issues. Our review is due soon. You're not going to get dropped at 66, Laurie. I just don't think you're going to get dropped at all. Thank you, Luke. That's very nice. Thank you. I really appreciate that. Like I said, we're all, this is a confusing and very frustrating program, and I really try to share what I know. I just think that, the good karma, I try to share what I know, send it out, it comes back. So, but thank you for the kind words. I really do appreciate that. T-Lux, you're late, T-Lux. We're getting ready to end this in 2 minutes. So, but good to see you anyway. Dwayne, if a person was on SSD until full time, they automatically convert you. They convert you because SSDI and full retirement are about the same. So you must be a fitness person. Yeah, every 2 or 3 hours, eat small, frequent meals, gallon to half gallon of water a day. Yeah, that's what I hear. Intermittent fasting also works. I've heard different things about that. Again, my buddy who is a teacher at Emory is not a big fan of it. He thinks that the body will, does not react well to fasting, but other people say it's great. Okay. Sherry says, I heard my case. 1, partially favorable, didn't go back to original date, February 22. Now, I'm going to go back for all this time. SSI Well, you for SSI, you only get paid as of the date of application. So if your application was after February of 22, it doesn't matter because SSI only get paid as of that date of application. So it may not make a difference at all. So yeah, take the partially favorable. Okay. All right, we're getting close to the end here. The lawyer will get his directly deposited. Yes, yes, they will get it. Yes, his fees have been approved. They'll pay him directly. Correct. But I would make sure he got his paid because every once in a while they don't pay him, and if that's the case, you should pay him. But normally they are. Um, could be. Yeah. Again, SSI. If you applied in 22, then that's the most you can get anyway. Okay. My pleasure. Thank you. Yes, thank you, Roy. Please hit the like button and leave me a review. That would be great. Um, okay. 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 I hear you. I understand. I know what you mean. It's a very, very, it's crazy how long it takes. And yeah, I know what you mean. Alicia, I'm sorry that it's gotten, I know. What can I tell you? I know. I know. Madeline says it's in Oklahoma. It's 60s and windy. Fire 2. Oh, I didn't know there was fire there. Okay. I'm going to answer two more, then we're going to go. Sleep apnea, does it qualify for disability? In theory, yes, but it's not gonna. It's not. Social Security doesn't consider that to be disabling impairment unless you can prove that you are just completely, unable to function the next day because of no sleep. Elliot, thank you very much for the super sticker. I really appreciate that. Okay. Let's see. Thank you for answering questions. Sure. All right. I'm going to ask two more. This will be it. Well, glaucoma, it depends on how, again, it doesn't matter. The diagnosis doesn't make you disabled. It's the effect of it. So how bad is the glaucoma? How difficult, does it make your functioning in terms of, getting around, doing any kind of work, not driving. That's not going to be a factor unless, because it would eliminate driving jobs, but it's not going to eliminate, getting to and from work. They assume you can take a cab or something or Uber. It's just, how bad is glaucoma? Would it affect you in any kind of job? Okay. Okay, let's see. All right, Kimberly says, thank you. Great. Thank you very much. I really appreciate that, Kimberly. Good night, Sherry. Good to see you here. Elliot, Elliot, you gave me a sticker, so I'm going to find your question. Okay, there you go. See? $5 super sticker. We'll do it all the time. Elliot is 61 and applied for SSDI back in September of last year. Gone through medical decision, now going through quality review. It seems to be stalled there for the past month. Okay, so what's going on is that your case was evaluated by an adjudicator, and the adjudicator requested medical records, and the medical records have come in, possibly, and assuming they have been, they are being sent to an in-house medical specialist the Social Security has employed to review cases. The medical specialist will look at the medical record, will report back to the adjudicator. There is enough here to say that Elliot meets a listing. There's enough here to say that Elliot's condition is so significant that he is not able to function in a work environment. The problem is that they don't have enough of these medical specialists. They don't pay them a lot of money. And that's why there was a rule that came down a few weeks ago that basically said in certain circumstances, if there's not enough medical specialists available, the adjudicator can make a decision without them, but only if there's not enough available. So it's possible in your jurisdiction there are enough specialists, but they're really overworked, and so it's causing a backlog. That's probably what's happening. So it could be stalled there because the specialists, which these are doctors who do this to make a little bit extra money, they only do it part-time. If they don't have enough people, but they don't have they're not down to so few that the decision maker that the adjudicator can make the decision without the specialist involved. But there's a specialist is involved. They have to wait to hear back. So this is basically, a medical specialist looking at the records has to look at them, and they can be maybe voluminous records. Get back to the adjudicator, then has to make a decision. But that's why it's been stalled. And this is part of the backlog in general, that cases at initial are taking a year and a half because of all this nonsense with the backlogs. But I hope that answers your question. And again, thank you very much for the super sticker. And yes, that gets your question answered. So I thank you for doing that. Appreciate it. I'll answer questions no matter what. But I mean, you make a good point. You were nice enough to shoot me $5, so got to get your question answered. I hope I did. Okay, that is it for tonight. We'll be back next week and 8:30 Eastern. I hope to see everybody here. Thank you very much. And again, if I can be of assistance, here's the link on the bottom crawl to ask for a case evaluation. And again, if you found this helpful, please review me on Google, on Avo. You can go to jonathanginsberg.com and you can see a place that says Review Jonathan. Just do that, or ask if the prior crawl I had a link to it. But yeah, if you would do that, that would be awesome. Really appreciated. And again, if I can be of assistance, let me know. Hope everybody has a great week, and I hope that it's warm where you are. It will be warm. Have a great spring. I think we're going to be spring next time, formally. And again, good health to everybody. I will talk to you next Wednesday night. Thanks a lot. Bye-bye.